Hello, this is Matt on the Moon Lambeau channel. Let's talk a little bit about what Judge Torres got wrong in her ruling yesterday. And this is subjective, but I think it's pretty obvious. I mean, there's this one issue in particular that everybody keeps, the attorneys within the community keep going back to, and I think that their positions on this are pretty damn persuasive, so I want to talk about it. Even so, the ruling on the whole was fantastic. I didn't expect us to get necessarily everything that we would want here. But I'll tell you what I didn't have on my bingo card was this determination from Judge Torres that programmatic sales do not represent any sort of illegal, unregistered securities offerings, this or that. That I wasn't expecting, because you're talking about just market participants like you and I purchasing XRP. Could be on exchange, could be done a number of different ways. But because look, I think even Ripple was expecting that to not go so well because they stopped programmatic sales like several years ago. And I would assume that it was anticipation of that potentially being more troublesome from a legal perspective. But then on the flip side, you have these institutional level transactions, which, let's just say there's some uncertainty. Now, does this mean something negative for Ripple's on-demand liquidity utilizing XRP as a bridge currency? Well, right now, David Schwartz seems to think the answer is no. I hope he's correct. He very well may be. But there's not complete clarity surrounding this. So I want to share with you what's been stated at this point. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Damn it. And if you don't like it, well, you can just get out. All right, so here's a headline from the Crypto Basic. Ripple CTO says ODL-related sales not a major concern for Ripple on SEC case ruling. Following the ruling of XRP as non-security by Judge Annalisa Torres, concerns have emerged about the classification of ODL-related sales. Ripple's chief technology officer, David Schwartz, took to Twitter to shed light on the matter. Schwartz said they are still trying to understand and navigate this legal matter. Currently, they do not have any ODL-related sales with a U.S. nexus. However, he mentioned that even if they cannot conduct those sales in the U.S., it wouldn't be a significant problem for Ripple. He explains that they can still operate ODL within the U.S. as long as the XRP used in these transactions does not come directly from Ripple. This means that if they ensure that XRP is obtained from other sources, they can continue to use ODL technology for cross-border payments within the U.S. Yeah, so think about this, and this is where it could potentially get hairy. This is one thing, anyway, to consider. So XRP, if you're talking about ODL, that's clearly consumptive use. Okay, but what if you are a market maker, so you have a bunch of XRP and it appreciates over time? Is that going to be considered to be an investment? Or would it be the case that you just happen to have it for the utility purpose, and over time, the price happens to go up? Well, here's what Bill Morgan shared. So he retweeted what I just shared with you from David Schwartz, and Attorney Morgan wrote, "I raised this issue a few hours ago. Although you say Ripple can work around it, the fact is the judge's reasoning on institutional sales is just not consistent with ODL customers not investing in XRP. Using it for payments and not expecting profits from holding it." Yeah, see, so there's a big part of the concern. Now, David Schwartz responded to Attorney Morgan and said, "The only way I can square it is if the logic is that on-demand liquidity customers weren't expecting a profit, but that it doesn't matter what they expected, only what a reasonable buyer buying from Ripple could have expected." See bottom of page 18 and top of 19. That is, however, very weird. Yeah, so think about that. That is a rather peculiar situation. Because again, he said, the only way that I can square it, the logic is that ODL customers weren't expecting a profit, but that it doesn't matter what they expected, only what a reasonable buyer buying from Ripple could have expected. It's so subjective at that point, though, right? I don't know. And then David Schwartz continues. He says, "But then it seems weird that it's a reasonable buyer and not a reasonable ODL customer. But that's just all I can think of, and it's quite possible that the real answer is something I can't think of. I definitely, before this ruling, would have thought that selling blind on an exchange where you may sell to speculative retail investors would be worse than selling to sophisticated buyers for a purely consumptive use. This ruling points the other way. Yeah, exactly. So that's what I was highlighting. That's when I was saying that, you know, this is the programmatic sales being approved by Judge Torres. Didn't have that one on my bingo card, right? Exactly. It's the exact opposite of what I would have expected, the exact opposite of what Schwartz would have expected, probably the exact opposite of what the vast majority or all of you would have expected, right? Programmatic sales, A-OK, institutional level with highly sophisticated purchasers, potentially not. That's interesting, let's say. You had former SEC attorney Mark Fagel jump in, though, and he responded to Schwartz and said, the ruling flipped the purpose of the securities laws on its head. Sophisticated institutional investors with access to information get the protection of the securities laws, but ordinary investors buying on exchanges who, per the court, were too dumb to know what XRP was, don't. You gotta love the way he words this stuff. I like Attorney Fagel, but come on, it doesn't mean that they were necessarily dumb. If there are all sorts of people out there who are intelligent and just they want to buy a bunch of large cap coins and then just hold for a long time because they want exposure to the asset class. Come on, man. And then on top of that, because you know what he's getting at, you know, do they know about Ripple? Okay, well, most first-time purchasers of XRP don't know about Ripple. They don't even live in the United States. And they just understand that, maybe they understand other things about how, you know, from a technological perspective, or they see what a different developer is doing building on top of the XRP ledger. But in terms of flipping the purpose here, it's just, he seems to be okay with less freedoms when it comes to making buying and selling decisions in markets, which I've always had a problem with. My stance has pretty much been, if you want disclosures to be made, okay, fine, have a requirement for disclosures, okay. But don't then say people can or can't purchase something. That's what especially when you get into the accredited investor type nonsense, I hate that crap. But look at what look at what David Schwartz said in response. And I think he's hitting the nail on the head here. He says, it's a shame you didn't share this insight with Congress back in the 30s when they passed these laws. Maybe it's time for Congress to pass new regulations to accomplish the objectives of these laws, as nearly every company in the space has been saying for years. Exactly. You look at what's been passed, it's already set, and so Judge Torres is just making sure that her ruling is in adherence with existing law. Maybe you should have thought about it back then. And Attorney Fagel has a position which I don't find compelling, but I think he's being intellectually honest, so I'm going to share it. He says, they wrote the laws broadly to be adaptable. Congress didn't consider insider trading either, but it's indisputably illegal despite any statute prohibiting it, because the SEC and the courts adapted existing law. And so David Schwartz responded and said there's a fine line between adapting existing law and making new law. The only category of security that applies to crypto tokens is investment contracts, and those require looking at the facts and circumstances of each offering to see if the agreement is an investment contract. Yeah, and he's spot on there. And then he says, to be clear, I mean native crypto tokens. Tokens that include legal rights to things like redemption or participation can fall into some of the categories of things that are inherently securities. And so, and I've highlighted this before. This is the definition of security. And you'll note that cryptocurrency and, you know, digital tokens, stuff like that, not in there. Certainly not in there. So this idea that, because look, I've seen him say stuff like this too. Okay, but what about the intent behind it? Well, you're assuming a lot, and it's not the written letter of the law. So I don't find those arguments compelling. I really don't. I think David Schwartz is spot on here. So yes, it's a little weird that things are upside down here. Even Attorney Deaton was talking about this in his live stream yesterday. I caught that. And it does still seem like there's going to be a fine path forward for Ripple, which is what we want. I would like, you know, that utility to exist utilizing XRP. And it's going to no matter what. The question is, would it be able to exist in the United States? It looks like the answer is probably going to be yes. According to David Schwartz, he's probably correct here. But I don't think there's, you know, perfect clarity on exactly what that's going to look like. So I'll keep tracking this and see if it changes the way that ODL flows actually have to flow. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.